He feels very strongly about a lot of things. Okay. Let me start right now? Okay. We rolling? Sounds good. Good evening. My name is Bill Livingston. I'm an attorney in Howell here. Let me just fix my microphone. I was born and raised in Howell. I am a member of Livingston Law, which is myself, my sister Katie Livingston, my father Tim Livingston, who's been around forever, some people may know. And we practice primarily criminal defense with a focus on court-appointed felonies. We do lots of other work as well. I've been involved in lots of expungements over the years, and I've studied this new law extensively, so I hope I know what I'm talking about here. So we'll get started here. Just a little disclaimer on this information that I'm going to give today. This is for adult expungements only. This does not apply to juvenile records. That's a whole different set of laws, and it was not touched by the clean slate legislation at all. So this is just about adult. I did my best to include information that would apply to most people. Obviously, there's a lot of information involved in these statutes, so I can't answer every question on what could happen with everybody's specific criminal histories. But if you have a specific question and you want to ask me afterwards, I'd be happy to talk to you. So just a little history of the clean slate legislation here. It was 7 separate bipartisan bills. It was signed into law by Governor Whitmer in October 2020, and it covers Michigan compiled laws 780.621 to 780.623. These are commonly referred to as the expungement statutes. I have created a hyperlink, and I will put these slides on my website, and I believe the library plans to put them on their website as well. If you're going through the slides and you're able to click on the hyperlink, that will take you directly to the statute website. You can look up any of these statutes on the Michigan Legislative website and read through them for yourself. They are kind of dry. They're written by lawyers in a way that makes people feel that they need us. So these are, as I said, commonly referred to as the expungement statutes, and most of the amendments and additions went into effect as of April 11th of 2021. Some of the effects of the clean slate legislation, this is obviously not all of them, but some of the major ones, it increased the number of felony offenses that can be set aside or expunged from 1 to 3 with certain limitations. It allows for most crimes that occurred within 24 hours and, quote, arose from the same transaction to be treated as a single conviction for purposes of determining eligibility, and I'll go more into that in a little bit here. It allows for automatic expungement of certain crimes under specific circumstances, so that will cover a lot of misdemeanors, and obviously we'll go into that as well. And it also now allows for expungement of certain crimes under the Motor Vehicle Code, which was not allowed before. And finally, one of the major ones as well is it allows first and only drunk driving convictions to be expunged. That was never allowed before. So if you got a drunk driving before, you were never allowed to expunge those until these laws went into effect. These are, in my opinion, this was great legislation. I know myself and a lot of attorneys in Michigan are really happy about this. It just, we see all kinds of people entangled in the criminal justice system, from people that were they had their first offense and when they were in their 20s and haven't gotten in trouble since, and it's still on the record. Unfortunately, we also see what we call true career criminals, but most of the people we run into are people that had either a bad time in their life or even just a bad day, and it resulted in a conviction that is still on the record. Effects of criminal convictions can affect driver's licenses, professional licenses, gun rights, employment opportunities. You can't serve on a jury if you have a felony, which I think most people would consider a positive. But in addition to that, I know one person here mentioned that it affected being able to get housing as well. So prior convictions can really affect your life for a long period of time. prior convictions, once they've been expunged, will no longer appear on a background check. That is the major draw towards expungement. That means that a potential employer or anyone from the general public that's not involved in the government, if they run a background check on you, they're not going to see that these convictions ever existed. Yes?
Question, is there some way for someone to search anything that was expunged? It wouldn't show up on a background check, but could they dig deeper and find expunged?
There are ways, and I can talk, and I do plan on talking about that a little bit later. But things like, if something was in the media, or if it was mentioned in a police report in a police agency that the court doesn't have jurisdiction over in another state, there are ways that people could still see it. So it's not a foolproof thing. But for most background checks that an employer is going to run, it's not going to show up on there. A study by the University of Michigan found that expunging records resulted in large gains in employment rates and wages. I don't know what their sample size was for that, but I've cited the study that you can go read if you'd like to. And that same study estimated that only 6.5% of all eligible individuals applied for and received an expungement within 5 years of the date that they were first qualified to have one. So most people aren't taking advantage of the expungement statute, which I think, is one of the reasons I really like the automatic expungement as well. But I think it's also, fear of going to court in front of the judge and trying to explain yourself, fear of thinking that you have to hire an attorney to do this, and I think some people just don't even know that it's an option for them. So the most important and difficult part of determining is determining whether you're eligible for an expungement or not. So the statutes define a conviction as any judgment of guilt by a court after a plea of guilty or guilty but mentally ill or no contest, or a finding of guilt after a jury trial or a bench trial. You may expunge up to 3 felony convictions, any number of misdemeanor convictions, but no more than 2 assaultive crimes between any of those. So it does define assaultive crimes in the statute. It's a pretty long list, so I didn't include it on my slide. But the MCL number is 780.681, and it includes some things that wouldn't normally be thought of as assaultive crimes, such as stalking, intentional discharge of a firearm. There's a long list of things that are considered assaultive crimes, so that's another thing you have to watch out for. If you have multiple felony convictions for the same offense, only one may be expunged if the maximum penalty for the offense is over 10 years. So if you were to get, say, two felony convictions for, say, distribution of drugs or something like that, and the maximum penalty is over 10 years on both of those, you can only expunge one of those. Question?
Maximum penalty, does that mean what you actually serve, or what the law says?
It's what the law says is the maximum penalty. So most of the time, if you're charged with a 10-year offense, you're not going to do anything close to the actual 10-year maximum. And generally, convictions that were set aside through other means will still count towards the number of total misdemeanors for expungement purposes. That would be things like if you had domestic violence that was set aside through a diversion program called 7694A. If you have one of those, you'd probably know that you had it. It's called the Spouse Abuse Act. Other things like the Home's Youthful Trainee Act, which allows youthful offenders to keep their records clean as long as they successfully complete probation. So if you had a conviction and it was set aside through one of those diversion programs, it would still be counted as a misdemeanor, even if the underlying crime was a felony.
So if it got reduced, it would count as a misdemeanor?
No, not just reduced. If basically, if you had a specific diversion program.
Just like hybrid stuff?
Yeah. Okay. If a prosecutor reduced the charge and you pled guilty to a reduced charge from a felony to a misdemeanor, it still only counts as the misdemeanor.
Right.
Does that make sense?
Yeah, well, because you were originally charged with the felony, it would still stay as a felony.
No. If say you're charged with a felony for like distribution of drugs, as I said earlier, and the prosecutor offers to drop that down to a use of drugs, which is a misdemeanor, and you plead guilty to the use of drugs, it's not considered a felony for purposes of expungement. It's still considered a misdemeanor.
No, I'm talking about if you plead guilty as charged with the felony, that it will reduce later.
Oh,
After you get off paper, after you get off your conditions.
that's a good question. You are correct. Some deals would say, if you successfully complete probation, it's reduced later. I don't know the answer off the top of my head. My thought would be that it would count as a misdemeanor if it's reduced.
That would be nice, because that would be 3 years rather than 5 years.
Ask me after this, and we can go over that together for sure. And then the statutes also added what they call the one bad night exception. That means convictions for crimes that occurred within a 24-hour period and arose out of the same transaction. Say you had a drunk driving third offense and you fought with the police, and it was a resisting obstructing. It shall be treated as one conviction.
Like a crime spree.
Kind of, yeah. Yeah, exactly. So, however, you can't do that for assaultive crimes, crimes involving dangerous weapons, or crimes with a max penalty of 10 years or more. There are a long list of crimes that are prohibited from expungement. Life offenses, child abuse, child sexually abusive activity, which would include possession of child pornography, use of internet or computer to commit certain crimes, criminal sexual conduct, assault with intent to commit sexual conduct, any felony domestic violence conviction if the applicant had a previous misdemeanor conviction for domestic violence. And then we have offenses involving forced labor or servitude and offenses involving terrorism. Those are obviously not very common. But also down here, you can't expunge any second or subsequent conviction for operating while intoxicated, any traffic offense causing injury or death, or any traffic offense committed by a CDL holder while operating a commercial vehicle, or was in any other manner a commercial vehicle, motor vehicle violation. I don't really know what that last section means, but basically if you are a CDL holder and you had a moving violation, it was a misdemeanor, while you're driving a commercial vehicle, you can't have that expunged, unfortunately. And then there's the automatic expungement, which is brand new. That was just created with this new law. And unfortunately, it doesn't go into effect until April 11th of 2023. And I believe the reason for that is they set up a fund to fund this. And it's going to take 2 years to build up the money for it, apparently. It allows for eligible misdemeanor convictions to be automatically expunged 7 years after sentencing. Felony convictions automatically expunged 10 years after sentencing, or completion of any term of imprisonment with the Michigan Department of Correction, which would be a prison sentence.
Okay.
Is there a question?
Well, you could still be on supervision and not be in penitentiary.
Correct. That wouldn't apply here because it specifically says, or completion of any term of imprisonment. So if you were just put on probation, it would go from the date of the sentence is how the statute reads.
Oh, good.
Yeah. There are many conditions that prevent automatic expungement, unfortunately. There's a long list of them. The statute up there is 780.621G. There's no automatic expungement of assaultive crimes, serious misdemeanors, crimes of dishonesty. All these are defined in the statute as well. Crimes with penalties over 10 years, crimes involving minors or vulnerable adults, crimes involving injury, serious impairment, death, or crimes involving human trafficking. So I am not, I'm not super confident in the automatic expungement process. It's, it's brand new. I don't know how well it's going to work. I know that sometimes bureaucracies, move very slowly on things. I think this is good for people that, wouldn't have no need or intention to expunge their record, so it'll happen anyways. But, I would be hesitant to tell people to rely on automatic expungement because there's a lot of things that can negate it.
So if you don't qualify for automatic, if you don't qualify for automatic expungement, you can still apply for expungement, it just wouldn't fall off automatically.
Correct. Yep. You'd have to take the proactive steps that we'll talk about in here as well.
Can I ask you a question?
Sure.
For mental health reasons, are there any exceptions? If someone has a mental health disability and did something when they were manic and they were given a felony, it's not a serious crime. I mean, it was just, anyway. it wasn't a violent crime or anything like that, and it probably should have been a misdemeanor,
Mhm.
but it wasn't. Would that, is there anything that you could
So
appeal to anyone for?
in criminal law, we see that a lot. Most crimes are committed as a result of substance abuse or mental health problems, a lot of times for both. And unfortunately, convictions that result from mental health conditions, are treated the same way as convictions that are, for any other reason. So there's no specific process for somebody to apply for expungement for mental health reasons. However, going through the traditional process and having, either explaining to the judge or having your lawyer explain to the judge what was going on at that time is probably going to go a long way, especially if, they're getting treatment and things are going well for them now. One of the major things that changed with the new statutes were the time limits. So for multiple felonies, you may apply at least 7 years after sentence was imposed or discharged from imprisonment, probation, or parole for the convictions, whichever is later. So if you were sentenced in 2015, put on 2 years probation, your time doesn't start until you finish your probation, likely in 2017. So for felonies, it's 7 years. That's for multiple felonies. For one felony and one or more serious misdemeanor, which is defined in the statute, or a first violation operating while intoxicated, you can apply at least 5 years after those things. And I've heard the term used, the last court event, basically. So once you're discharged off probation is when that time would start. And then for one or more just regular misdemeanors that aren't considered serious misdemeanors, it's 3 years after those events.
So it sounds like it's case by case rather than the whole docket, right? Everything you've done, it sounds like each one you want to get expunged is a separate movement.
There's been some.
Jumping ahead.
No, it's a good question because there's been some debate and some discussion about that. The way they wrote that statute.
That's why I'm asking, do I have to do a motion for each one?
No, as long as it was in the same court. So if it was all in Livingston County, you could do it. Well, if they were in front of different judges, you're supposed to do them differently as well. So, yeah, I would file them separately with each judge that sentenced you. If that judge is no longer there, then you'll be assigned a random judge, and they could probably hear them all at the same time. Yeah. Our judges in Livingston County are pretty good, though. I know that they're treating this statute pretty liberally and giving these out as long as people have been good, law-abiding citizens.
All of them?
Not necessarily, but yeah, I won't. I'm not going to get into specifics. So serious misdemeanors, as we discussed earlier, include assault and battery with or without injury, including domestic violence, breaking and entering or illegal entry, contributing to the delinquency of a minor, indecent exposure, stalking. There's a full list. That's not everything, but those were the most common ones that I saw on there.
So it's good to know that a simple assault is a serious misdemeanor.
Yeah. I don't necessarily agree with that, but I didn't write it, so. Then we go on to how do you apply. So most expungements use Michigan Forms 227, MC 227 and MC 228. I've put a link on those right there. I've also put those up on the table there if you want to grab each one of those. So we'll go through those right now. Actually, I'm going to pull it up on the screen here as well. All right, this is Form MC227. So this is the actual application, and this is the first thing you need to fill out in the process.
So do you do this on your own, or do you need an attorney to help you?
You can do it on your own. You never need to hire an attorney for anything. As an attorney, I'm always reluctant to tell people that they don't need an attorney because that's when things go wrong. But it is a process that there's specific instructions. If you flip to the very last page, there are very specific instructions on how to do this, what steps you need to take, and when. So I will start with those. So first step is determining whether you're eligible to apply. And obviously, we just went through a lot of that stuff. That is the most complicated step, especially if you have more than one conviction on your record. And then you have to fill out this application. It says using a separate application for each court. So they're not really clear on whether they mean each judge or each county court. I have done it where I just file one application, and actually in every one that I filed, the presiding judge was no longer on the bench, so they just assigned it to a new one. So that is kind of, like I said, in an abundance of caution, I would probably file a different one for each judge. And if they assign it one judge for both of them, they'll hear both of them at the same time. If you're asking to have a conviction set aside because the offense was committed as a direct result of being a victim of human trafficking, there's a separate form for that. I can get more into that if somebody has any specific questions about it, but I've never, ever had anybody ask me about that. Find out the exact date of each conviction and each charge from the court. Get a certified copy of each conviction from the clerk of the court. So how you would do that is you would actually go to the court. If you were convicted of a misdemeanor, you'd go to the district court clerk's office. Felonies, you'd go to circuit court clerk's office. You'd tell them what the case number was and that you need a certified copy of the conviction. There is no actual document that says conviction on it. What I usually get is the judgment of sentence, but the specific form that you get isn't ultimately that important for most judges that I've been in front of. You can get the judgment of sentence or an order of probation or a register of actions, but it does need to be certified, meaning that the clerk's office will stamp it. They'll charge you $10 plus I think it's $1 per page to do that, and they call it certified. I don't know what that means or what it proves, but that's what you got to do. And then you have to fill out the actual application itself. So I'm going to go up here. You'll see a spot on the top left. You'll fill out the district or circuit court number. In Livingston County, we're the 53rd Judicial District and the 44th Judicial Circuit. You'd fill out your case number and judge on the top right. If you have multiple cases, you would check that little box that says this application includes multiple case numbers as listed in item 1. And then you got your court address, telephone number. That's not ultimately that important, but I like to fill out everything, obviously. In almost every criminal case, it's you check the box for state of Michigan as the plaintiff, and then you put your own information in here.
Can you real quick repeat the judicial and the
Yes.
circuit?
We are the 53rd Judicial District and the 44th Circuit.
Okay, thank you.
No problem. As we go down here, you'll see that you have to list out each crime that you're asking to have expunged. You put the name of the crime in here, and if you get the judgment of sentence, it'll have like an abbreviated version of the crime name. I always just write it exactly as I see it on the judgment of sentence. And then the charge codes, you'll see it's either called an MCL citation or a PAC code, PACC. And that's basically the statute number that you were convicted under, and it should have that information on the judgment of sentence as well. Then you'll need the date of conviction and the case number. Going down here, there are some statements that you have to attest to. 2A, B, and C. You check one of those for either asking for more than one felony to be set aside, that's 2A. One or more serious misdemeanor to be set aside, that's 2B. And first violation, operating while intoxicated offense to be set aside, that's 2C. Oh, and then down here, 2D, only one felony set aside, and E, one or more non-serious misdemeanors. So you just have to just figure out what you're asking to be set aside and check the correct box there.
So your serious misdemeanors will count as filing for a felony?
No, serious misdemeanors, let me go back here.
The time is the same as a felony, but is that the same as any?
If you're asking for a serious misdemeanor, it's 5 years. So one felony or multiple serious misdemeanors, I believe
It
is
won't count as one of the three then, right?
correct.
Okay. Will an R&O?
R&O is a felony.
Yeah, you didn't get convicted of a felony, that misdemeanor.
Was it an attempt R&O?
Yeah, attempt.
Okay, that would be a misdemeanor, yes.
Would that be assaultive?
I would think it would probably count as an assaultive, so serious misdemeanor.
Okay.
And then 4A here, yeah, to check no other application has been filed to set aside any other convictions. That applies to most people, I would say. If you have filed another application before this, you would obviously check 4B.
What have you got, I mean, I have a lot more, like, of the same crime,
Uh-huh.
I have a lot more, like shoplifting, I was, manic depressed with the crime and stuff
Mhm.
like that. But I'm having like over 10. I mean, do I just fill in sending another piece of paper with it? Or?
Why don't you talk to me after, and we'll talk about the specifics. I'd probably have to see the actual criminal record, and I'd be happy to take a look at it for you if you want, but. And then number 5, I've not had any convictions deferred or dismissed, or have had the following convictions deferred. That would be through, like we talked about earlier, HYTA, the Homes Youthful Training Act, or the Spouse Abuse Act, or something like that. And then 6, there are no other criminal charges against me. You can't have any criminal charges pending while you are asking to expunge your record. So once you fill out that, you would sign on the bottom here, but you would do it in front of a notary public. So I know the post offices usually have notary publics employed. I would assume that the library, no,
But
okay,
I'm working on it.
all right,
The bank, First National had one.
okay.
Bank of Ann Arbor, I don't know, but I can find that out.
Yeah, a lot of professional offices will have notary publics, and we'll do it for a small fee.
The library should have one. I believe it should.
So you just got to notarize the statement, and that's basically you swearing to everything that you put in the application. Once you do that, you take the application to the court with the certified copies of your convictions. You would give them the application with those certified copies. They would process it, and then most courts, and every time I've done an expungement in Livingston County, will give you your hearing date the day that you turn in your application. And expect that hearing date to be a couple months out. You're looking at probably 90 days, because what happens next is you got to send in everything to the Michigan State Police. They have to run a background check on you. The FBI runs a background check on you. The Attorney General's office takes a look at it, and then they send letters back. So it does take some time once you file the application. Unfortunately, you got to kind of be patient for it. So.
So 90 days just for the hearing after you do all this.
That's my experience, yeah, usually a couple months. So after you get your hearing date, you want to go and get your fingerprints taken at the, most of the time you can go to the Livingston County Sheriff's Office to do it. You should call ahead, tell them that you need fingerprints for an expungement. There's a specific form, and it's listed in the instructions here, R1008. You used to need 2 copies of fingerprints. I don't know if they've changed that or not, but you send both copies, both fingerprint cards that you get from the Sheriff's Office, you send to the Michigan State Police.
How much did the fingerprints cost?
I don't know the answer to that.
They were 15 or 20 when I, like, 3 or like 7 years ago.
Okay, thank you. Once you have your hearing date, you'll see that information gets filled out on page 2 of the page 3 of the application. And once you have that hearing date, you make copies of everything. So you'll want 3 copies, 4 copies of everything. One will stay with the court. You'll send 1 copy to the Michigan State Police with the fingerprints. And as I said, all this information is right on the instruction sheet. You'll send 1 copy to the Michigan Attorney General's office, and you'll send 1 copy to the prosecuting official or officials that were the ones that prosecuted you on the underlying case that you're asking to be expunged. If it's in one county, it's just going to be, if it's in Livingston County, it's going to be the Livingston County Prosecutor's Office, most likely.
You can make copies at the library too. What is it, 10 cents a page, black and white?
Yeah.
Now, if you're asking to expunge a misdemeanor marijuana conviction for use, For use, possession, or sale of paraphernalia, you use a different form. That's Form MC227A. I did not print that form out because it's very similar to this form. The only difference is the law allows for these misdemeanor marijuana convictions. Once you file an application, prosecutor's office has 60 days. 1 second here. 60 days to rebut a presumption. So what that means is once you file an application to set aside a misdemeanor marijuana conviction, there's an automatic presumption that conduct that you got charged for would have been legal under the new legalization of marijuana laws. The prosecutor's office has 60 days to say, wait a minute, even if he had committed the crime today, it would still be illegal. If that happens, there's a hearing held, and then the judge makes the ultimate determination. But if the prosecutor doesn't respond within those 60 days, the application is automatically granted.
So it's like a parking ticket if the cop doesn't show up.
Kind of, yeah. Exactly. Yeah, so this is all what I just explained. They treat those differently, obviously, because use and possession of marijuana is generally legal now. Once you have your hearing, which like I said, would be probably about 90 days out from the time you file the application, this is going to be in front of the judge that sentenced you, or it will take place in front of a different judge if that judge that sentenced you is no longer on the bench. They'll assign a random judge. Obviously, each judge is different in what they want to hear from applicants. Most of the judges in Livingston County are pretty good about not grilling people. They just want to know that you haven't been in any more trouble, that you've been gainfully employed, or doing something productive with your time and been a productive citizen, basically. So, obviously, an attorney can prepare you for the tendencies of the judge. I'm not saying that you necessarily need an attorney for one of these, especially if you have like one conviction, and it is something that anybody could figure out how to do. But a lot of people are nervous about going in front of a judge, especially because probably the last time they went in front of the judge was for their sentencing. So the prosecuting attorney will also have an opportunity to give the judge their opinion about whether or not your record should be expunged. The judge obviously does not have to go along with that opinion, or if they're saying they don't want it to be expunged, the judge can still expunge it. It's ultimately their decision. But they also may speak to any victims. If it was an assaultive crime, the prosecutor's office is required to reach out to the victims, or at least try to contact them under the Crime Victims' Rights Act. And the victim has the right to be present in the courtroom. So, if you're trying to expunge a crime that was emotionally charged, it could turn into a rehash of that at the hearing, unfortunately. But it's just something that victims have a right to be at the hearing for an expungement, and they also have the right to just send in a letter if they want, and the prosecutor would read that on their behalf. So ultimately what the judge has to find is, and actually, you know what, I will pull up the order here as well. If you want to pull out the other sheet that I handed out today, this is the order on the application to set aside the conviction. So this is what the judge would ultimately sign after the hearing. And I always advise people to fill out what you can on this order. Does everybody have a copy of that?
Yeah.
Okay.
I got a question, just real quick.
Sure.
Underneath the sentencing, what is CTN/PNC or TCN? And then next to it, SID. On ours, which is like right here.
Yeah.
The box.
So, yeah, these right here. So, honestly, I have no idea. I've never filled them out. I've never had a problem with it. DOB is date of birth, so you may want to...
I don't even have that on it. I don't.
Oh, you don't on that one? Okay. I hear you.
I just don't want to leave anything blank.
Yeah, these, I've never seen those filled out, so. Obviously, you would fill out this top section the same way you did the application, this section as well, and then anything that you don't know the answer to, you can leave blank, because once the judge makes his ruling, you're going to hand this to the judge, his or her ruling. You're going to hand this to the judge. They're going to fill out the rest of it, their findings. They're going to, obviously the applicant has or has not been convicted of more than 3 felonies. They will fill out what needs to be filled out, and if they're granting it, they will click number 15 here. Application is granted as to the following convictions listed in item 1. They could put all convictions if they're granting the full expungement, and then they sign it.
What kind of percentage of applications get approved?
I would hate to put a number on it, but I would say most. Yeah, most.
And then like after it's expunged, like if a company does a background check, it will just not be there.
Yeah, so,
It's not like a cops where they could still see that it was there, but it was expunged.
right, if they're doing a public background check, it's not supposed to be on a public background check, and that is the job of the Michigan State Police to make sure that doesn't happen. Now, whether or not that happens is obviously outside of an attorney's control. Yes?
Can you still have your police report FOIA though?
No, actually, once the order is signed, the order is sent out to the Michigan State Police to remove it from your criminal database, as well as the arresting agency with instructions to make any case information about that specific case non-public.
Even on deep search or specialty search? Because I'm thinking that that's a loophole.
So there's, expungement, there's always, in my opinion, with the internet now, there's always going to be a way to find something about somebody online. I don't think there's ever going to be, there's never a guarantee that, somebody doing a deep search on you isn't going to find, something about this conviction.
They tend to find a lot of information.
Yeah. I guess it depends on how much money and time a person's willing to spend on digging into your record. But, from the point of view of the courts, they send the order out to the Michigan State Police and the arresting agency, and both those are supposed to make the information non-public. And if anyone ever does divulge that information that has legal access to it, they can be charged with a crime. So,
Yeah, misdemeanor.
yep. So what the judge has to find is that circumstances and behavior of the applicant from the date of the applicant's conviction or convictions to the filing of the application warrant setting aside the convictions and is consistent with the public welfare. Be prepared to discuss what you've done since your conviction. You might want to bring, proof of employment, letters of support. You could even bring people in to talk for,
Your therapist is a good idea.
Absolutely, yeah.
Yeah, that's where your mental health stuff really helps.
Yes, absolutely. Yeah, even a letter from a therapist is great.
Yeah, relapses too, that works real well too, like people that got in trouble with drugs on relapse, or the therapist, a letter often helps.
Yep. I always like letters from therapists, employers. A lot of people, you'd be like, here's, 5 letters from my cousins. And I'm like, well, yeah, exactly. So, it's very clear in the statute that expungement is a privilege and not a right, and you must convince the judge that you've earned it. Some judges that's easier to do with than others. But as I said, most of the judges that I've dealt with in Livingston County have been pretty good about them. The court may take testimony, ask for affidavits to be filed. I've seen them take testimony before. They'll have you raise your right hand, swear to tell the truth, and the judge may ask you questions about what you've been doing with your life. I have never seen a judge ask for affidavits, which is basically a sworn statement. But if the judge decides to deny your application, you must wait 3 years before trying again, unless the judge unless the judge specifies in the order an earlier date, which they're allowed to do. So, if you go in and your application is denied and the worst happens, I don't think it would hurt to ask the judge, if they could write in the order that you can try again in a year. You know what I mean? If your application is granted, a judge will usually sign the order immediately, give you a copy before you leave the court. Keep a copy of that for your records. And I know some people have been proactive. The court are the ones that are supposed to send this order to the Michigan State Police and the arresting agency. I know that some people and some attorneys, myself included, will mail those orders yourself to the Michigan State Police and arresting agencies just to make sure. Yeah. And it can take some time too. It's not like the Michigan State Police, gets that order and immediately removes the record, I don't think. I mean, it should happen that way, but I know I've seen it take several weeks sometimes for those to get removed. So if, you're on a time crunch or you need it expunged for a very specific reason, you may want to run a quick background check on yourself, which costs about $10 from the Michigan State Police website, and it'll show any convictions that are,
Can I check with it?
yeah. Yeah, that'll show if it's still on there or not.
Yeah.
And then the exact language of the statute is upon entry of an order or upon the automatic setting aside of a conviction under Section 1G, the applicant for purposes of the law is considered, it's supposed to say is considered not to have been previously convicted except as otherwise provided in this section in Section 3. So once you have that judge's signature on your order, you can lawfully say that you have not been convicted of those crimes anymore. And if you're asked on, say, a job application, if you've been convicted of whatever, you can lawfully say no if it's been expunged. The non-public record that the Michigan State Police will keep has a record of the arrest, fingerprints, conviction, sentence, and expungement. That's what they keep. And that is, it's available only to specific government agencies and individuals for specific purposes, and those are spelled out in 780.6232. It's basically law enforcement, courts, the governor, apparently, Attorney General's office, and only for very specific purposes as well. And as you said, it's a misdemeanor, but there are criminal penalties for people who divulge information contained in non-public records outside of that permission given in the statute. And one of the benefits, obviously, is you may not be prosecuted again for an offense that you had expunged.
It's like an annulment, it's like it never happened.
In a way, yeah. And these are the limitations, though. So no information can be fully erased, as we discussed. Anything on the internet, posted by media, records retained by police agencies outside of the court's control, say from another state, all those can remain. I have heard of an agency that will do a deep dive and try and find any evidence that they can find in Michigan or other states of that conviction and try and get it removed for you. It's called the National Expungement Database, NEDC. It's a private firm that does this kind of work. I have no idea how much it costs. I would imagine it's very expensive. But if it's something that, you absolutely cannot, you want to make sure that this doesn't get out, then that may be something that you consider. I'm sure there are other firms that do the same thing. So, Secretary of State driving records cannot be expunged. So if you have an operating while intoxicated and you get it expunged, it's still going to be on your driving record.
Does that preclude the others
What do you mean?
from being expunged? I have 10,
10.
but I don't have 10 assault. I got 10 misdemeanors, but I got 2 DUIs. So obviously, the one DUI will not be able to be expunged. Does that preclude the other misdemeanors from being expunged?
So you can only expunge a DUI, or OWIs are called in Michigan. You can only expunge those if you've only had one. So if you've got a second, you can't expunge either of them, unfortunately.
Yeah, would that affect the other misdemeanors trying to get them expunged?
No, it shouldn't.
Good, thank you.
It does not protect you from civil liability based on the offense. So if you there's a victim of your crime and they were suing you for damages, you can't use your expungement as a defense. It does not allow you to seek damages for incarceration, so you can't try and get money for being put in jail for a crime that was later expunged. It does not relieve you of your obligation to pay court order restitution. And you may still be considered, it still may be considered a prior conviction by courts, law enforcement, prosecutors, for purposes of charging a new crime as a second or subsequent offense. So if you get a crime expunged from your record, you commit the same crime afterwards, they could still charge that as a second offense. So that basically covers all the main points of it. Sure.
So you said the DUI doesn't come off Secretary of State, so my husband chose not to employ someone who has a DUI because they can't work in Canada because they can't go. So how would that pairing, if they got it expunged, but it's still on Secretary of State, who speaks to who?
That's a very good question. And I've had clients that have had OWIs and have gotten into Canada. I know that it's not always caught. I don't know what Canada has access to. I don't know if they have access to Secretary of State records. I don't even know if they have access to criminal history or if they just ask the question and the person answers it. But,
Is that really, you can't go to Canada if you have DUI?
Visa, would you?
I'm sorry, what was your question?
Is that really the thing? You can't cross the border if you have a DUI?
My understanding is Canada's very strict, and if you have an OWI, they can bar entry from, I mean, they can bar entry for any reason because it's an international border, but
That's what I was gonna ask you also, how does it affect the visa?
I don't know the answer to that.
I'm worried about the assault of one. I mean, I've done everything that I need to do, and it's a,
That was the,
it got reduced, it was a felonious.
okay,
Yeah, like, for example, Australia doesn't believe in just doing your time. They want to see that you've been rehabilitated.
right.
Will that work in your favor, or would you know? Would that be a question that I could ask you?
I think, I think,
That would be another one about Canada.
yeah, I think international law is beyond my purview, but,
Yeah.
you know, that's a good question
'Cause if you
that I don't know the answer to.
Just kind of see Australia, it'd be hard to do unless you were probably rehabilitated by their standards.
Right.
Because it's their country.
Yeah, I know, you know, countries have wide latitude to reject people at their borders for really any reason. And, you know, our expungement laws may not necessarily mean anything to them. So, you know, if they're asking you whether you've been convicted of a crime or been arrested, I guess legally in the United States, you could put, no, I haven't been convicted of this crime because it's been expunged. But, you know, if they may feel differently about that answer.
Yeah, I would just say, like you said here, you can legally say, no, I've not been convicted of this crime. I wouldn't even say the expungement.
That's probably what,
We use the same
I'd be like, no,
database,
never.
yeah, I'm not sure. I'm not sure what information the United States shares with, you know, Canada or Australia.
They're gonna be like, liar, we have.
That's right. One last thing. There's been a big debate about this very specific language. So you'll see in the application under number 2 here. Actually, I'll just pull it back up here. It says, I am requesting more than one felony to be set aside. At least 7 years have passed since sentence was imposed or discharged from imprisonment, probation, or parole for the convictions, whichever is later. I have not been convicted of any offense during that time. So the real problem comes with that language because if you're asking to expunge multiple crimes, obviously there was a crime committed in the waiting period from the time of the first one to the time that you applied. So, you know, there's been a lot of discussion amongst the defense bar in Michigan. It sounds like it was kind of a drafting error, and I've heard rumors that a fix is being made. But, you know, what you kind of got to do is if a judge brings it up, you know, that's kind of an argument that, you know, I don't think most judges are going to bring that up, but it's kind of an argument that has to be made that, you know, it was the intent of the legislature to allow for multiple convictions to be expunged, and, you know, that language obviously would not allow it. So I don't think you're going to have an issue with any judges on that, but it is just, you know, something to think about, and we're hoping that the legislature fixes it sometime soon, but who knows. Are there any other questions?
So it's 7 since 2, not 7 since 1, right? The 1 still covers 5, right?
Yeah, so for one felony, it is still 5 years, yes.
Okay, I'm still good. Okay. For now.
Let me see.
Yeah, that's the way I.
Yep. Mm-hmm.
Thanks.
Yes.
Say someone was convicted or charged with felonies, a couple felonies for like kind of the same thing.
Mhm.
It was all 3 identical, the same thing.
Yeah, anyway, and then how long? That was 12, and then in,
I don't remember.
2016,
Mm-hmm.
there was a shoplifting charge, and it was a misdemeanor.
Yeah, after I had my 3 felonies, I think I might have got 1 more shoplifting charge and then none since. Like,
Okay.
It was all due to medication and bad, you know what I mean? They were,
No, mismanagement.
yeah, I mean, they were all bizarre items and stuff, you know, I
Right.
wasn't selling anything
They
to
just
get
got sick
drugs.
of.
And they could see that, that's why they didn't send me to prison. But like, I mean, I would go at like 4 in the morning and I wouldn't even be slick, like, they would catch me in the middle of the aisle, like trying to tear something open with my teeth. You know what I mean? So it was obvious.
Yeah.
Mismanagement.
Weird, and that hasn't, you know, I mean, everything's been straightened out medication wise.
He doesn't need to know that.
Well, I was gonna talk to him after about it anyway. I was gonna talk.
Yeah, if you want to talk afterwards, I'm done here anyway, so we can wrap this up, and then I can take specific questions.
Yeah, I mean, I just wanna know,
So-
like,
Amber, if we want to